defendant filed a motion for summary judgment, and you would like to use a set of facts as evidence in your response to the defendant's motion for summary judgment. Now, during the discovery, you did not discover that the evidence or the facts existed, or you knew the facts existed, but you did not identify those facts during the discovery period. Can you now use those facts as evidence to support your response to the defendant's motion for summary judgment? Potentially, yes. And how do you do that? You file a motion to the court asking the court to take judicial notice of those facts. And that's what we're going to talk about today, and the requirements to use those facts as evidence. So let's get started. Courts can take notice of certain facts without formal proof, but only where the fact in question is one not subject to reasonable dispute, and that it is either generally known within the territorial jurisdiction of the trial court, or two, it is capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Now, let's look at some examples. These facts are scientific facts. For instance, when does the sun rise or set? Matters of geography. For instance, what are the boundaries of a state? 3, matters of political history. For instance, who was president in 1958? And to help me explain judicial notice and how it works, we're going to look at case law. Shahar versus Bowers, 11th Circuit case out there in Georgia. And I remember this case because I was a practicing attorney in Georgia. I had been practicing at that time roughly 2 years, so I was very interested in the case. So in 1997, 2 recent newspaper articles reported that Georgia's former Attorney General, Michael J. Bowers, admitted to having an adulterous affair in the past with a woman employed in the Department of Law. In a lawsuit against Bowers in the district court, Robin Shahar, the plaintiff, sought to use the information as evidence to support her claim that Bowers discriminated against her based on her sexual orientation. So let's look at the facts. The plaintiff accepted an offer to join the office of the Georgia Attorney General, Michael Bowers, the defendant, as a staff attorney following her graduation from law school. In 1990, Shahar was planning a wedding to her partner, Francine Greenfield, for the following summer. The state of Georgia at that time did not recognize same-sex marriage. Shahar's marriage to another woman was brought to the attention of Bowers. Consequently, Bowers withdrew Shahar's offer of employment on the grounds that her employment would constitute the AG's tacit approval of same-sex marriage and thereby endanger the effectiveness of the office. Shahar sued the Attorney General, Bowers, for violation of her rights of exercise and association, equal protection, and substantive due process. The district court granted the AG's motion for summary judgment. Shahar appealed. Now, on appeal, the appellate court affirmed the district court's decision. But what was interesting in this case, and what is still interesting in this case, is there were judges on the appellate panel who dissented and made dissenting opinions opposite of the judges who affirmed the district court. And I'm going to present both sides. The appellate court's opinion is as follows. Ms. Shahar asked us to take judicial notice of the conduct of one person, Michael J. Bowers. And she asked us to take judicial notice of conduct which is not his official conduct. An example of his official conduct, which might be judicially noticed, would be that he issued a particular official opinion on a certain date. The court continues, she has shown us no case, and we have found none, where a federal court of appeals took judicial notice of the unofficial conduct of one person based upon newspaper accounts or the person's campaign committee's press release about that conduct. We are not inclined to extend the doctrine of judicial notice as far as plaintiff appellant asks us to take it. The dissenting judges stated this: Bowers' public statement is relevant to whether his asserted fear of adverse public reaction to perceived sexual misconduct of persons in the Georgia Department of Law was a bona fide reason for terminating Shahar, and to whether he acted as a non-discriminatory decision maker in the Shahar matter. Judicial notice is obviously appropriate. The newspaper account was a statement by Bowers admitting his conduct and asking forgiveness for it. The statement was made through Bowers' political campaign headquarters and was published nationwide by newspapers, radio, television, and magazines of national circulation. Surely, this court can know the content of a statement that is relevant, accurate, because made by Bowers himself and known to millions. And I presented this case because I wanted you to see both sides of the argument. What do you think?